Braidwood v. Becerra is the first major legal challenge to the Affordable Care Act's Preventive Services Coverage provision. So this is a provision in the ACA that requires all forms of private health insurance coverage in the United States to provide coverage of certain clinical preventive services. And that includes immunizations recommended by the Advisory Committee on Immunization Practices, services with an A or B rating by the United States Preventive Services Task Force, as well as certain women's preventive services as recommended by the Health Resources and Services Administration, essentially the contraceptive mandate. And several employer plaintiffs have challenged this law because they object on moral and religious grounds to purchasing health insurance coverage that includes some of these services. And so, for instance, the most prominent objection that they have is to providing coverage for PrEP for HIV, which prevents transmission of HIV. So that's really at the heart of the case. They've really brought two major sets of claims. One is a set of administrative and constitutional law claims, really challenging the authority of all of the recommending bodies on grounds that they were unlawfully appointed or have had this authority unlawfully delegated to them by Congress. And then secondly, they've brought a Religious Freedom Restoration Act claim suggesting that they should be exempted from covering PrEP for HIV based on their religious objections. I would say that additionally, the Religious Freedom Restoration Act claims really do also pose a unique risk because essentially if the plaintiffs prevail and the court agrees that they're entitled to object on religious grounds to purchasing health insurance that includes coverage of PrEP for HIV, this is a very slippery slope. Braidwood poses the most significant threat to preventive healthcare that I believe we've really ever seen. It, as I mentioned, is the first major legal challenge to the ACA's Preventive Services Coverage provision. And that's a provision that has provided coverage to at least 150 million Americans of essential clinical preventive interventions, vaccines, cancer screenings, PrEP for HIV. And these are really essential tools if we want to prevent disease, if we want to detect disease early so that we can treat it before it progresses, so that we can save lives. And Braidwood really does threaten to upend the entire framework on which the ACA requirement is based. So there's a real risk that the courts rule that these bodies are operating unconstitutionally, and we see the coverage requirement stripped away. Braidwood is currently pending on appeal before the United States Fifth Circuit Court of Appeals. It's set for oral arguments on March 4th in New Orleans. So the court will hear the arguments of both sides in the case, and then it likely issue a decision within several months after that. I do expect that this is a case that is very likely to reach the Supreme Court, given the significance of the questions in the case, the constitutional administrative law questions, the religious freedom questions in the case. These are all issues of really great interest to the current Supreme Court. And so I think that we can expect to see this case go further. Most of the media attention that I've seen to this case revolves around PrEP for HIV, and that is a very significant aspect of the case. But anyone interested in public health and healthcare, anyone interested in immunizations or disease screenings or contraceptives should be paying very close attention to this case because all of those questions, the constitutionality of all of the bodies that make recommendations for all clinical preventive interventions in the United States are sitting before the courts right now.